update. So hopefully I can provide you with some information so you can go forward and practice real estate properly with all of these changing rules. Now, I want to mention these changing rules because even after this webinar today, I think last webinar, I had said something in the morning, and then by 3 o'clock the afternoon, the order had shifted. So one of the things to keep in mind is that we are in a constantly changing, constantly moving environment, not only in real estate transactions, but in our general worldwide experience with coronavirus, just from a health perspective, as well as from an economic and business perspective. So things change, and when they change, they're changing rapidly. And sometimes it's hard to get really accurate information about what those changes are and how they affect you. So what I want to talk about today is what is my understanding of everything that's come down as of 12 o'clock p.m. on May 14th of 2020, with the understanding that it might change. So as Nikki said, go ahead, stick your questions in the Q&A. I have a couple of topics on my mind that I'm going to go through. One of them is going over the new real estate guidelines that were set forth by the California Department of Public Health and how, if any way, that's changed how you're practicing real estate. The second I'm going to go over is the eviction moratorium, any changes that have happened there, and some frequently asked questions that I get from our agents at RE/MAX Estate Properties. And then I'm going to talk very briefly about some legislation to keep an eye out for that has an impact on you, your clients, and our industry. And then a quick reminder that CAR is constantly updating their forms, so stay apprised of all of those. Those are my topics that I have on the docket for today, and then I'm going to open it up after I give my briefing for questions and answers. So feel free to put them in as we go along, and at the end, I'll comb through and address as much as I can for your burning questions today. So the first thing I want to go through is the real estate guideline that was set out by the California Department of Public Health last week. They set forth, it's about 5-6 pages long, and it is specifically geared towards real estate transactions, and it includes two main topics. The first topic it includes is real estate showings. It talks about prevention plans, cleaning and disinfecting, as well as how to handle clients when they're in the property. The other thing it talks about is opening businesses, opening offices. So CAR has come out with the guidance, and I do agree with their guidance based on what the California Department of Public Health has published, that offices are technically allowed to open. Now, the problem with that is that you're going to see most offices do not open with good reason. And that is because our industry can largely work from home, and those businesses that are able to work from home are encouraged to do so very strongly, because the guidelines for businesses are opening are very extreme. I mean, temperatures have to be taken, there have to be constant cleaning and disinfecting of workplace environments, and those disinfectants, as we know, are hard to come by. So there's a very high barrier to reopening an office. So don't be surprised, upset, worried, concerned if any of the offices are not opening anytime soon. And it's not just because those hurdles are high, but it's because for our health, safety, welfare, we want to make sure people are protected, especially in businesses like ours, where people can largely work from their house. Now, I've got 3 kids at home. I understand that the feasibility of it can be tough at times, but that's the general feeling and consensus amongst the offices and in the community. So stay tuned to see how that all plays out. But I'm going to go ahead and put a link to the California industry guidance in the chat. I'm going to do that right now, so bear with me. All right, so that link that I just provided is this. And what this is it's a PDF that was published on May 12th from the Los Angeles County Public Health Department. And it goes through, it has an overview of coronavirus. We're not going to go through that. And then it has your workplace specific plan if people are opening up their businesses. There's shown property specific plan, employee training that's going to be required when offices do finally open, PPE, the protection gear that's going to be required when offices do open. Employers will have to provide all of their employees with those kinds of that kind of gear. Control measures and screening, things like taking temperatures, keeping records of it. This is more workplace. I'm going to keep scrolling. I know it's probably dizzying. Here we go. Cleaning and disinfecting protocols for shown properties. Don't worry about reading this right now. I'm going to give you a brief overview of them in a moment. But I just wanted to show you this as an example that there's comprehensive guidance on how to go about doing what it is we're doing. So what I just showed you is that link that I posted in the chat. The big ticket items that this guidance has set forth that were not in place before are these. You have to have a written prevention coronavirus plan. Now, it has to explain that you have to wear masks, that surfaces need to be disinfected, that if you're feeling ill, you won't enter the property, and that you have to clean your hands and disinfect before you actually enter the property as well. So this prevention plan, a requirement of showings now, is that that prevention plan must be posted at the entrance of the property in a conspicuous place before you can enter the property, before you can show the property. So a COVID-19 prevention plan, again, must be posted at the entrance of the property in a conspicuous place before you can have anyone enter for a showing. It doesn't need to stay up there the whole time the property is listed, unless you have people who are coming in from a lockbox, in which case you do need to have it posted the entire time, since it needs to be there for every single showing. You also have to talk about the rules before you and your clients can enter into the property. And they have to acknowledge that they've seen these rules. Now, the rules that we have to follow, luckily for us, are all contained in the PEAD. So technically, you could put the PEAD, laminate it, stick it on the front of your property for a showing, with one exception. The rule does say that we have to have what are called infographics. You've all seen them. They're that little picture of someone sneezing or of hands being washed. It does say infographics are required on the plan. So if you want to add infographics to that prevention plan that you're going to put on the front, go to your local printer. I know Graphics and Design, who's relatively local, has ones that they're making for different brokerages. They made one for us that we disseminated to the RE/MAX agents. And I know they're making them for other folks as well, with the different rules and the infographics on them. So that needs to be in front before anyone comes in for a showing. The other thing that has slightly changed is that not only we've known that you've had to clean and disinfect between every single showing. They've upped the ante a bit. You have to clean and disinfect before every showing, as well as after every showing. Now, I get a lot of questions about what about vacant property. They've not drawn any distinction between occupied property and vacant property. So they just say showing. So for all showings, you have to disinfect before to get rid of any coronavirus that was in there ahead of time, and disinfect after. And that includes all high touch surfaces, railings, guardrails, doorknobs, if people are washing their hands with the sink, all of the fixtures and faucets. So all high touch areas have to be cleaned and disinfected. They recommend that you introduce fresh air during the showing, open windows to the exterior if the weather permits. But one thing that they do actually require now is that all doors where people are going to be walking through, bedroom doors, front doors, back doors, are to remain open during the showing to avoid people having to touch doorknobs. That's just good practices. I hope you guys have been doing that so far already with showings, but if you haven't, it's now mandated that any doors that people are going to be walking through should remain open to avoid anyone touching doorknobs. And then the other thing, and this also I know can cause some distress for folks, is that all properties have to be equipped with proper sanitation products. Because upon entering a property, everyone must either wash their hands or use hand sanitizer. And I've been asked, what if we don't have sanitizer? Can we use gloves? The guidelines do not say gloves. I know there's a lot of different opinions about the efficacy of gloves and masks for that matter, but gloves in particular. The guidelines specifically say nothing about gloves. They say you must wash hands or sanitize upon entering the property. So if you're an agent who's showing the property, you're either going to need access to soap and water to wash hands, or you're going to need to bring with you hand sanitizer. Of course, the number one question I get is, I haven't seen hand sanitizer at the store in 2 months. How in the world am I supposed to do that? Luckily, some off-brand markets, I personally have seen hand sanitizer at my pet store. I've seen them at Home Depot. Target gets restocked. So, and there are still some online services, not Amazon because they're out, but other websites that you can go to look for hand sanitizer, because it is going to be required if you're doing showings and you don't have a place for your clients to wash their hands. So those are some of the big changes. All of the other requirements that were already in place, like for LA County, you can't have more than 2 people who are residing together plus 1 real estate agent at a showing at a time. That rule is still in place. And by the way, that's an LA County rule. That's not necessarily across the state of California. So that rule is still in place. All the traditional LA County rules for showings are still in place. The tenant in LA County or the occupant must leave during the showing. That's still in place. If you want a tenant to leave and you're in LA City, you got to get their written permission. All of those things are still in place. This is just the addition to list that came from the Department of Health County. So the other thing is they reconfirm that we have no open houses right now, that you can't have a showing on a walk-in basis, that everything needs to be by appointment only to ensure social distancing occurs during the entire showing. And in LA County, that's going to include the 2 people in a household plus an agent rule. And so they're confirming that as part of the California guidelines, that no open houses, no walk-in basis, that everything must be by appointment only. So I want to kind of go on a bit of a tangent on this no open houses issue, because I have heard from our agents as well as from some folks at the South Bay Association of Realtors that there are a couple of agents, hopefully not with our company, but a couple of agents who are holding open houses. They're not calling them open houses when you ask them, but they're putting open house signs on lawns, and they're sitting out front of the house underneath a pop-up tent at a desk. And when you walk up, you can put your name down on a list, and then all of a sudden you've got your appointment. Well, that is actually in violation if they're doing it on a walk-in basis, meaning that person has not called ahead to make an appointment and set an appointment time to show up, then they're in violation of the guidelines. And so the first step when you see that is tell that realtor, remind them that that is a violation. If they are not paying any attention, my best recommendation is talk to their broker. Now, I know in one circumstance, the broker was the agent and they were on their own, and it was a solo person who was doing this. And really, it is a police issue. So most of these guidelines have been set out by the California Department of Public Health, but the Safer at Home order is a county ordinance, and it has misdemeanor what's called consequences. So the enforcement mechanisms are not through the South Bay Association of Realtors. It's not through necessarily, it could be DRE issues because it is a misdemeanor, but it is largely through the sheriff's office. And so if you see someone who is blatantly doing it, really that's the alternative. So one of the things you have to weigh and balance is this something that is causing a threat to health, safety? You're really concerned about it. If you're ever concerned about health, safety, welfare, go ahead and call them. So that's the step process, and I've been asked that a couple of times. It's not perfect. So much of these orders is relying on citizens, individual citizens, to follow them. And it's not really well set up for those folks who plan not to follow them. So we have to keep that in mind, but no open houses, still appointment only. And yes, if you want, you can set one appointment after another, so long as the people are waiting in their car or far on the street where they're maintaining all social distancing guidelines. So that is the real estate guideline that I wanted to talk about. Again, the link is in the chat for you to check out that guideline. The next thing I want to head into is what's really changed with this stage 2 opening, and in particular in LA County. There were a lot of rumors over the last week about LA County's not going to modify their Safer at Home order. They're going to extend it for 3 more months because if you recall, it was set to expire on May 15th of 2020, which is tomorrow. Well, they didn't extend it indefinitely. Let me put it this way. They extended it indefinitely, meaning they have no new deadline. but in extending it, they also modified it. So there's a new order that's come down, and I will go ahead and put that link into the chat as well. Nope, wrong link. I'll get it for you. Hang on. Here it is. Okay, so this is the new Safer at Home order. Oh, I just put it in panelists. Sorry, I put it here. There you go. Now you guys have it. So this is the new Safer at Home order, and it was updated on May 13th, which is yesterday of 2020. This is for the County of Los Angeles. Now, keep in mind, and I know we talked about this last time, it takes you back to Civics 101. If you took government in high school like I did, if you'll recall, we always have to follow the level of government that is above the next level of government. So we as a nation have to follow the federal laws. Then, so long as we're sitting within the bubble of the federal laws, there can be state laws. Those state laws can be more restrictive than the federal laws, but they can't violate them. So they can't be broader than the federal laws. The same goes for our counties and then our cities. So we have your state law bubble, which is California law, which is Governor Newsom's orders, which moved to stage 2 and allowed certain reopenings. And then within the state of California, we have the County of Los Angeles. The County of Los Angeles can have a more restrictive order. It can tighten the bubble, but it can't expand it beyond what California has allowed. And then within the County of Los Angeles, every single city, Los Angeles City in particular, puts their bubble really small. So every single city has the opportunity to tighten their bubble. They can't go beyond what the county has said, and they can't go beyond what the state or the federal government has said. So what I just put in the chat is a link to the County of Los Angeles's updated Safer at Home order that came out yesterday. Now, you don't have to worry about reading the whole order. That's what you're here for. I'll summarize it for you. We have not really changed. We as real estate professionals and in real estate transactions, both residential and commercial, are essential businesses. So you will continue to operate as usual. The only difference is you're going to follow the guidelines that the California Department of Health has set out, in addition to the guidelines that LA County had already set forward, which hopefully you're all very familiar with. So what did this order do? This order in LA County opened certain public areas, talks about tennis court. This particular order doesn't, but other orders talk about tennis courts, golf courses, beaches, which opened yesterday, trails with limitations. But the main business that it opened up is retail. It opened up retail not for people and customers to come inside the store, but it opens it up for curbside pickup and delivery for, I think, all of retail except those that exist inside malls or in interior centers. It also opened manufacturing and logistics for those retail businesses. Things that don't directly impact what you're doing on a day-to-day basis, but just as a person living life in Los Angeles, may impact you in that way. So that's the updated order. You're not going to find anything in there in particular affecting your business that's changed because we are already deemed essential. So the next topic I want to go to, and then we'll open it up for Q&As and I'll go through all of your questions, is the eviction moratoriums. I'm getting a lot of questions from our own agents about tenants rights. What in the world is happening? I do want to draw a distinction between LA County and LA City. LA City has come out, and I'll go through it in a little more detail. LA City has come out with a pretty restrictive ordinance on evictions and moratoriums on foreclosures. So if it really is going to depend on what city you are in. For example, the city of Manhattan Beach has their own eviction moratorium and foreclosure ordinance. So each city, as things are progressing, is coming up with their own. So my recommendation would be, if you are working with a landlord or a tenant in a specific city, go to that city's website. They almost all now have coronavirus dedicated sites, and poke around for an order. And if you can't find one, just go ahead and call them and ask them about where to find that order so you can get up to speed on what's happening in that city. So in the general state of California, there is a moratorium on evictions if someone is unable to pay rent as a result of coronavirus. Either they've lost income, their income has been modified, or their household expenses are higher as a result of coronavirus. Basically, if it's related to coronavirus, which this day, the middle of May of 2020, it's pretty impossible to say anyone isn't affected by it one way or another. So what does that mean? What is this moratorium on eviction? Does it mean that the tenant just doesn't have to pay rent or just stops paying rent? Not necessarily. It's a rent deferral. So you don't have to forgive a portion of the rent. So if your tenant's paying $1,000 rent and they say, I can only pay $500, you don't have to modify the lease agreement and knock them down to $500 a month. You can defer the $500 to a later time. And depending on the city, will dictate how long they'll have to pay. So in Los Angeles, for example, in residential, looks like it's going to be 12 months. I think for commercial, it looks like it's going to be 3. Different cities are going to have different timelines for how long people can pay after the moratorium emergency is over, and then they can pay the deferred rents. But here's the bigger issue. The bigger issue is the courts are closed in California, absent an emergency to health, safety, or welfare. So if you have a tenant, for example, who has a dog that they're not allowed to have in the property, in LA City now, it's explicitly not allowed to evict for that. But in the rest of the cities that doesn't have the same rules as LA, what are you going to do? I mean, you should consult with a landlord-tenant attorney. Your clients should consult with a landlord-tenant attorney because they may have some ideas of what to do in the interim. But if the courts are closed to all evictions except emergency evictions, dealing with health, safety, welfare, like someone's, doing drugs or cooking drugs or dealing drugs or anything related to that, how are you going to get them out if you can't actually get in front of a judge and a jury and get a court order for an eviction? So there are some practical problems that go beyond what the actual ordinances say. When those are lifted, and you want to make sure that you're prepared and you're lined up to address any issues that have come up, which is why they should talk to the landlord-tenant attorney anyway. But it's a real issue from a practical perspective on how to deal with tenants when it's not a non-payment of a rent issue. So that's where we are as far as the state of California. The city of Los Angeles, something I want to point out really quickly is that they have just recently come out with a new ordinance, 2 new ordinances really. One is requiring that every tenant in the city of Los Angeles be given what's called let me get the exact language for you. It is a COVID-19 renter protection fact sheet. And I will share my screen and show you all. So this, in the city of LA, is now what every single landlord is required to give to a tenant by May 27th. So that's 13 days from now. Now, this does not just apply, having to give this, to rent-controlled units. This is for all rental units in the city of Los Angeles, all rental units, not just rent-controlled units, all of them in the city of Los Angeles. This has to be given to the tenants by May 27th. What it is it's telling the tenants about the eviction moratorium, telling them about their eviction protection rights, telling them about payment options and repayment options. And then if you scroll down further, it also gives the tenant a form that they would use in the event that they are not able to pay due to coronavirus. I recognize that this is going to likely cause an increase in the non-payment of rent, and it's problematic for that reason. But this is very consistent with the way the city of Los Angeles works through the housing department in making sure that they're acutely aware of their rights to defer payments if they deem it's necessary due to coronavirus. So this form can be found on this website, which is the Los Angeles Housing and Community website. And I'm going to put a copy of this website into the chat as well. I'll put the link there. And you can see the 2 ordinances that were passed. This second ordinance here also says that you can't evict a tenant unless you have just cause right now. So it is a complete moratorium on those kinds of evictions. They said that not having a pet is not one of the reasons they can do it. They go through, sorry, let me get to here, prohibition on rental evictions. So they're actually stopping pretty much every eviction except health, safety, and welfare. So I'll go ahead and put that link. I know I'm putting a couple of links in there so you guys can pick and choose what you like. And give me just a second. All right, this is for Los Angeles City. Just keep that in mind, City of LA. This would include San Pedro, by the way, so City of LA. Then the last thing I want to talk about, so that's really what I wanted to go through with eviction moratorium. It is statewide, and it is getting, by city, you're going to see, again, the bubble getting smaller in certain cities and more restrictive. LA City has come out with a very restrictive version of their eviction moratorium. So keep in mind, again, that notice, that 2-page notice, is required to be given to every tenant in the city of Los Angeles by by May 27th of 2020, with no exception. So the last thing I want to talk about is legislation. I'm not going to go into detail. I don't presume to know anybody's political preferences, your position on any of these eviction moratoriums, and I'm not here to espouse any kind of opinion on any of that. What I do want to do is I want to make sure everyone is aware there is substantial litigation being discussed and passed through the Assembly as well as the Senate in California to address these eviction issues, to address what's going to become the unaffordability of housing that's going to increase the crisis in California exponentially. So these kinds of rules, I know one of them, I hope everyone was aware and got the CAR news flashes, that one of the rules says if a tenant is in the process of being evicted, they can petition for the court for relief, and that relief could actually reduce the rent amount in the rental agreement by 25%. That's not a deferral, that's actually a reduction in rent by 25% for the following 12 months, but then presumably rent control would still apply on top of that. So those kinds of bills right now are going through the House, they're going through, we have the Assembly, they're going through the Assembly, they're going through the Senate. And so it's really an important time as a real estate agent and an advocate for your clients who invest in real estate to make sure that you're staying informed. CAR provides a lot of information, and lobbying for that matter, with these different bills. They're looking at changing the Prop 60, Prop 90. They're looking at reassessments. If there's typically right now, right, in Los Angeles in particular, if you transfer property between a parent to child, you're exempt from a property tax reassessment. They're looking at changing that for Prop 13 and saying that the exemption only would exist if that child occupies the home as a primary residence. So I don't want to opine on a position one way or another. If you support it, know about it. If you oppose it, know about it. My only point is to let people know that this legislation is going to happen. It's going to happen rapidly, and our voices, hopefully, matter, and to stay informed about it. CAR does a really good job, I think, of giving a summary of some of these updates. So check out their websites, check out their updates, their legislative updates as well. And then the last thing is just a reminder that they're also updating their forms for coronavirus regularly. In our normal lives, we only have to work with 2 CAR updates typically, right? One in the middle of the year, then one in December. And that's when we have to learn all our new forms, really understand what the changes are, and go from there. Well, the coronavirus forms are being updated regularly because they came out so quickly for good reason. They had to address a problem that happened rapidly and created a lot of legal consequences. So stay up to date on the forms. Make sure you're using the most updated form, which you can find in your online version. So that's it that I had on my list to talk to today. Thank you for sticking with me for a half hour of me talking. I don't think my kids could do that remotely. So I'll move to you guys' Q&A right now. And so bear with me as I read some of the questions. What are proper ways to serve notices to tenants should you not want to physically go to the property for fears of contracting COVID? So notices to tenants, depending on the notice you're providing, you can hire a service company to go ahead and serve any kind of notice that's required there. That would typically, though, be a 3-day notice to pay or quit, or an eviction notice, which has to be delivered personally. The 3-day notice has to be posted and mailed if they're not home. But you can't do those right now because they're the eviction moratorium. So really the notices that you'd be providing are likely a 60-day notice to vacate. Those can be delivered by mail. So will you be sending us a copy of this guidance? The guidance link is in the chat. So I've put all of the links that I showed you guys today in the chat. So check them out. Since we're independent contractors, with each of our offices disinfect each day for us, that would be what the offices should be doing, would be when they do finally open, they would disinfect. But because you're regular people in the office, they would likely need to take everyone's temperature, and people would need to agree to follow all of the coronavirus plans if they were going to enter. So it depends on what that office's plan is going to entail. But as independent contractors, if you're using those offices, you would be required to follow their coronavirus prevention plan that they put in place. Again, I don't think you're going to see a lot of offices open right now, in particular because of the ability to work from home for real estate individuals. How do we handle brokers' opens with people coming in and out? We should not be doing any brokers' opens. So there should be no open houses, no brokers' opens. Remember, you cannot have any house open on a walk-in basis. Every single thing has to be by appointment only. So no open houses, no brokers opens, nothing is just open. R6 Distillery in El Segundo selling hand sanitizer every day. There you go. R6 Distillery selling hand sanitizer every day, and they're in El Segundo. You can find it. If you really want to find hand sanitizer, it is out there. Oh, scratch my question on brokers open. Sorry, I didn't scratch it early enough. How do we go about with prospects showing up with child or children to showing? It's a great question. So there is no prohibition on children coming in. It's a bad idea having 3 of my own. The week before coronavirus measures said everyone stay home, I was acutely aware of the virus being an issue, so I took my 7-year-old with me to Target. And we were walking through, and he kept his hands in his pockets the whole time. He was being great. And then we got to the checkout stand, which is about here on him. And with his hands in his pockets, dutifully, of course, he starts rubbing his body on the conveyor belt that's going to bring all of everybody's stuff that everyone has touched through the checkout stand. So I say this only to say, we can't exclude kids, but it's a terrible idea to bring a child to an open house, or not an open house, to a showing, because they just can't help themselves. They can't quite grasp the issue of not touching things. But can we disallow them? We cannot. The only thing we can do is stay within the 2-person limit. So if one parent comes with one child, what I would suggest is saying, I highly recommend we don't bring your child inside. They often have a hard time not touching things. Of course, it's your decision. You'll need to sign a PEAD on behalf of your child as their parent guardian, right? And if they insist, bring the kid in. But if 2 parents come with one child, you now have 3 people who are all from the same household, but that is 1 too many people. So you'll just need to help your clients remember that the maximum number of people who can enter a home are 2 people from the same household with 1 real estate agent. Based on the pop-up open house example you gave, why shouldn't the showing person show the property if the buyers sign an AD form? They can show the property. You can't have an open house or any showings on a walk-in basis. That's the difference. And with the AD form, we're conflating 2 different rules, right? One is clear cooperation policy, which deals with the AD form. And then the second is the California Department of Public Health and LA County orders regarding COVID. COVID doesn't care, any of the guidelines, they don't care whether you have an AD or not. It's irrelevant. All they care about is you have an appointment specifically to see the property. You can't just walk in or do open houses or showings. How about a neighbor sees you and they want to see the house? They just need to sign an AD form, assuming it's in the coming soon section. So again, we're conflating two different issues. One issue is clear cooperation, totally different. And then the second issue is COVID. So for COVID, AD is irrelevant. Again, appointment only, even if it's a neighbor, appointment only. I mean, you can make an appointment that day, but appointment only. Can a buyer's agent show a property with appointment and signed forms without the listing agent? How would the property be sanitized in that case? It's the seller's responsibility ultimately to sanitize the property, and sometimes the listing agent will take on that responsibility if the seller's out of town or unable to. So a buyer's agent can show a property with appointment and signed forms, and if there's a lockbox on the property, my recommendation, if you're the listing agent, is make it so you can only get the code if that person calls you. So two things. One, you can ensure that they have a PEAD form, and two, so you can make sure the seller knows to sanitize before and after. So they're making realtors housekeepers too. You know, they're putting the burden on the seller. Technically, the burden is on the seller, but often as realtors, sometimes we take on those burdens as well. For the showing, absolutely. We are responsible. It says specifically the real estate professional must sanitize before and after the showing. Is there a way to conduct brokers' open houses in the same fashion we're allowed to do public showings with scheduled appointments and signed PEAD? The virtual caravan is great, but not the same. So I do know that some agents are having back-to-back appointments. So they might have a showing at 1 o'clock, they might have a second showing at 2 o'clock, a third showing at 3 o'clock. There's nothing wrong with that. So long as it's by appointment, it's not on a walk-in basis, it's not just people coming in off the street. But the key is that you have to leave enough time, and it says it in the guidance actually, you have to leave enough time to sanitize the property before and after each showing. So if, for example, you have the 1 o'clock to the 2 o'clock, you're going to sanitize it in between. And that is required in the guidance. So you could do it. In theory, you could have back-to-back-to-back appointments. You just have to make sure that there's time and resources to sanitize in between each showing, and you don't ever go above the guideline of 2 people per residence plus an agent. And if it's just one agent, then it would just be that person. Okay. If a tenant did not pay May 1st rent of $2,500 and is moving out on her own, no eviction, am I able to take it out of her security deposit? Again, if they didn't pay rent, then it's not, you're not waiving the rent, it's a deferral. So if they're moving out, you'd likely be able to deduct that from the security deposit, but you should verify it with a landlord-tenant attorney who works specifically on those issues. How should the COVID form be sent to tenants? It doesn't say, which is very interesting. So my recommendation is I would mail it as well as do an email courtesy copy. What is fine if tenants are not served to tenants or tenants state they did not receive notice? I know that was a little typo, so I'm going to assume what you intended. What if they claim they didn't get the notice? That's why I always recommend the email courtesy copy. I've actually been in court in my previous career life. I did very, very contentious, typically high dollar amount evictions. I never did the eviction attorney run-of-the-mill stuff, but I had a couple of really big ones, and one of them came down and the tenant denied ever receiving the 60-day notices for it was a Strand home for like $15,000 a month or something. And they denied receiving the notices. And I had sent an email courtesy copy, and we had our service person come in and say, I mailed it. And he said, I never received it. And I said, well, I also emailed the courtesy copy. And the tenant said, well, that doesn't count. And the judge sided with me. Now, that's not something you can always rely on. You want to make sure you have a record of mailing it. But email courtesy copies are very, very helpful. Does the COVID-19 renter protection form, can it be sent by regular mail? To my knowledge, it doesn't say. I don't do landlord-tenant work in the city of Los Angeles. So if you're concerned about what type of mail You might want to check with a landlord-tenant attorney in the city of LA. But again, I would recommend mail and as well as email courtesy copy. You can always do certified mail, just don't do return receipt because you don't get that back. What are the penalties if you don't give the notice to tenants in the city of LA? It's all through the housing department in Los Angeles. They have a board, and it would likely go through the rent control boards because they're probably going to be the people who hear it. Where you probably get the most flack is if the tenant brings it up to them or reports you. I don't know the exact consequence. Are required to give LA City renter protection notice in the city of Redondo Beach? No, just the city of LA. Where can we find the information for Prop 6090? I would do likely a Google search. Oh, that's Deborah. Deborah, if you can't find it, email me and I'll look around for it for you. I actually look at the bills on the legislature's website, which I know is a little eye-crossing for most. I can send that to you if you want. Just email me after you see if you can find it. What exactly do we need to provide to tenants? Is it the COVID renter protection fact sheet? It's both pages, and remember that is only for the city of Los Angeles, not the county, it's the city. My broker said it's okay to do open houses if the property was empty. He also checked with South Bay Association of Realtors. I don't know what to say about that, but your broker might want to look into it again and see if that's still the case.
We're not advertising to do any open houses at all.
Thank you. Thank you, Nikki. So no open houses. That's my understanding.
We're not telling anyone to do open houses, so I'm not sure where that came from.
Great. So we have no idea where that came from. Didn't come from South Bay Association of Realtors. Definitely wouldn't come from me. It is really explicit in every guideline I read that there are no open houses. On the listing side, why is there not a COVID form attached to the RLA to put sellers on full notice? Did I miss that somewhere? There is a coronavirus listing addendum. I don't know if it's attached to the RLA or not. That's a zip forms question, but there is a addendum to the listing agreement that you should be using with your RLA. Should I keep several copies of the PEAD at my vacant listing? I recommend you get that PEAD in hand before anyone ever visits the property. So for example, if you have a vacant listing, you've got a lockbox on it, you make that agent call you to get your lockbox code. And in order for them to get the code, they have to first send you the PEAD. You shouldn't be having any people show up at the property without that already signed. Governor Newsom made mention to the prohibition of children to showings. Can in the last 2 days, do you have any awareness? Oh, I didn't know. So if Governor Newsom mentioned kids at showings, I'll look that up. Thank you for telling me. And see if there's anything specific. I definitely know that they are discouraged from coming to showings. It's a terrible idea. Whether they can actually exclude them or not, I didn't know. If I'll look at that. Thank you, Debbie. See if Governor said absolutely they're not allowed. If they're not allowed, then you can say no. I would be shocked because it is they're a protected, families are a protected class. So I would be surprised if they actually said that you could disallow children, because as I mentioned, a family is a protected class, and a family includes a parent and child, grandparent, children, things like that. So it'd be surprising if they said they're not allowed, as so much as it's highly encouraged or discouraged to bring a kid to a showing. But you never know, all sorts of crazy things are happening right now. I'm seeing PEADs that aren't specific, that aren't property specific. Is that okay? If we can do non-specific, can we get a PED signed today and use it for an extended period of time? That's a great question. CAR came out with a guideline that they said that you can do a non-specific PEAD, meaning you can put in there for all properties shown today, but they recommended that it only be used a day at a time. So if you're doing multiple showings in a day, you get a PEAD signed for that day, saying properties shown on May 14th of 2020. And then you get another one for whatever other day you're doing showings if you don't want it to be property specific. So that's the guidance they provided. And for that particular issue, I'm in favor of following their guidance. The only option on the SBA or open house form is virtual. So where to advertise? I will let Nikki, do you know the answer to that? The only option on South Bay Association of Realtors open house form is virtual. So where to advertise?
I'm honestly not really sure what that means. We have the virtual caravan, but that's for realtors only. So that's not for the public. So I'm not really sure. Maybe Denise can add more to her question.
Yeah, Denise, do you want to ask a question down below? I'll get down there next.
Yeah,
and
we can add more to the Q&A and we can cover it. Thanks.
Great. Can you define sanitize the property? I would define it as well as you would, because there's no very clear definition. What I view of it they talk about hand sanitizers and sanitizing. My thought is you have to use a sanitizing product, a Lysol or something of that nature, or natural sanitizer. And you have to use it on all surfaces that are touched, doorknobs, handles, guardrails, countertops if they're being touched, a sink if it's being used for hand washing with the soap jar. So in my mind, it means using either sanitizing wipes or spray wipe. But my recommendation when it comes to those kinds of things is to use your very best judgment. The goal is not to skirt around the issue. The goal is to really address the problem, which is a virus. And the virus lives on surfaces. For how long? We don't know. But so it would be to sanitize it, to clean off those surfaces. Are agents representing owners and landlords permitted by law to mail the COVID renters protection form to the tenants? So it would be property management if that tenant is already in place. If it is and remember, City of LA, this is City of LA. So if you are putting in a new tenant in the City of LA, the realtor should absolutely include that as part of the packet that they're giving them in the rental process. For past tenants, I recommend reaching out to the landlord, making sure the landlord knows they need to provide this to the tenant. If you represented the tenant, then you can provide it to the tenant directly. But are you required to get involved in the landlord-tenant relationship? No, the landlord is ultimately responsible for providing this notice. But as their trusted real estate advisor, you come across as a very knowledgeable person dealing with their property and helping them comply with rules that they might not be aware of by providing them the form, making sure they know they need to give it to their tenant. Again, City of LA only. What exact surfaces are we sanitizing between showings? They say all high traffic areas, all high touch surfaces, and they also provide, I'll read it, a bit of a list. Oh, I didn't write it down separately. So it's in the guideline. And it talks about counters, doors and cabinet handles that are touched, key lock boxes, keypads, toilets, sinks, light switches, etc. So my recommendation is use your best judgment for high traffic areas, for areas that we think are going to be touched. Again, staircase rails, guardrails, anything that's helping people that they grab onto, doorknobs, light switches if they're turning them on, that kind of thing. The addendum for sellers is CAA. Not sure what that means. If you want to clarify if it's a question, if you want to clarify if that's the question, you can re-ask and I'll address it, Gloria. What if you need a handyman to enter the property before the listing? Do you need a signed PEAD? Yes, the PEAD should be signed. So it's not mandatory by law. It's not mandated by law to have the PEAD signed. What is mandated by law now is that you have those showing guidelines, remember those instructions, posted at the entrance of the property in a conspicuous place before anyone enters. That includes inspectors, handymen, roofer, contractors, whatever is happening where people are coming in as part of the real estate transaction. That coronavirus, prevention plan is required in the front of the property. So the PAD, while it's not required by law for that handyman, my opinion, and if you're a RE/MAX agent, we've made it mandatory. My opinion is, yes, it's absolutely something that you should have signed as a handyman coming in during the real estate transaction, the PAD before they come in. If you're a RE/MAX agent, it's mandatory as part of your file because it's so important. How about the landlord gets the tenant after May? Does the landlord still need to give a 25% discount to the new tenants? The law has not passed yet. This is not on the books. This is legislation that is coming through the pipeline that will likely be modified as it goes through. I personally think there are massive constitutional issues. It, in my opinion, constitutes a taking under the Constitution without just compensation. My own personal little legal opinion. But so it's not law yet. Don't need to worry about how to implement it right now. But I mentioned it just to give you guys an idea that there is legislation coming that we all need to kind of be aware of. In either if you support it. If you oppose it, make sure your voice is heard. Can we recommend prospects to do what your son did, put hands in pockets or behind them? Well, we saw how my son's story turned out. It turned out with him rubbing his whole body all over the conveyor belt exiting Target. So it doesn't work well. I think you can tell people that kids have trouble keeping their hands to themselves and you recommend not having them, but I don't, you know, ultimately if a parent's going to bring them, unless Governor Newsom set something up 2 days ago that says you can actually exclude children, you're going to have to leave it in that parent's discretion and then sanitize like crazy anything that the kid has touched. Letting everyone know, oh, thanks for the clarification, Gloria. Okay, letting everyone know the COVID addendum for listing agreement, thank you, is called the CAA. So the coronavirus addendum and amendment. So there is an amendment to the listing agreement for coronavirus. All right, I think that was all. Oh, one more question. If I'm just remodeling, not selling, I assume I should still post the guideline notice at the front door for plumbers, electricians, etc. We'll still have them sign the PEAD. Well, if it has nothing to do with the real estate transactions, your own home, you're just working with contractors, they're their own essential business. So construction is an essential business. They're allowed to perform work and they actually have their own guidelines for their own employees. They have to provide face masks, all sorts of things. They have workplace notifications that are required. They have to have hand washing stations. It's a very involved process. I happen to know more about it than I would like because I'm married to a contractor, but they're very involved and construction is essential. They are allowed to perform remodels. They're allowed to build new homes. They're allowed to come in and fix your roof leak and tend to your landscaping. They are required to follow their own guidelines and they need to do that. So the PEAD as well as the prevention plan up front are really for real estate transactions. They are not required for traditional construction if it's not related to a real estate transaction. But if you're doing repair work under a request for repair, retrofitting, anything related to your real estate transaction, then that is when you have to follow the prevention plan posted at the door, as well as my recommendation strongly is to have the PEAD signed for anyone who's entering the property during your transaction. All right, I hit all the Q&As, Nikki.
Awesome, thank you. Thank you for being here, and hopefully we'll have you back in a couple weeks again because I'm sure there'll be all this different things happening within the 2 weeks, just like every time.
Exactly. It is my pleasure. I hope you're all doing well and staying safe. And I know sometimes it's tough to stay in tune and stay updated and stay involved, and it can be overwhelming. So coming to these kinds of webinars or watching them back if you missed something or something was confusing or can be really helpful. So kudos to you guys for being here.
And all of our videos, including this one, are all on the South Bay Association YouTube page. It's SBAOR on YouTube. And you'll be able to find all the videos, including Melanie's previous ones. Thanks, everybody. We'll see you soon.
Bye, guys.
Thanks, Melanie.
Yeah, my pleasure.